Back in the days that my 18-year-old son likes to refer to as the olden days, videocassettes still seemed pretty neat. They were the first practical technology to allow people to watch movies in their own homes at times of their choosing. The only problem was the tapes were super easy to copy. In this case, the plaintiff, Gianitsios, held the Australian rights to distribute videotapes of a number of Greek language movies. Unfortunately, they discovered that other parties had copied those tapes and were supplying them, presumably at a cheaper price because they hadn't had to pay for the rights. They placed what's known as a trap order, where they pretended to be a buyer and ordered bootleg copies of the movies. They used these as evidence to seek an Anton Piller order, that is, an order compelling the other parties to allow what amounts to a search of their premises. Anton Piller orders are quite rare, partly because the other party is not heard on the application. If the other party knew the application was being made, the application would have no point. The whole idea is to be allowed to obtain the evidence before the other party has a chance to destroy it. But such an imposition on them could never be granted lightly. In this case, Justice Young briefly reviewed the circumstances in which Anton Piller orders would be given in copyright piracy cases like this one. His Honour said, ordinarily in this country, Anton Piller orders are only made if there is a large number of films or tapes involved and the defendant is in the position of a transitory trader, such as a person who trades at the markets or whose warehouse is in some temporary premises. The plaintiff, however, says that in this case he will not get a proper remedy unless an Anton Piller order is made, and it does seem in the present case that there has been a barefaced disregard of the plaintiff's rights by the conduct of the second defendant. The Anton Piller order was granted. From this case, it is made clear that an Anton Piller order can be made in relation to all sorts of evidence, not just documents, if there is a risk that without the order, an otherwise meritorious plaintiff may be denied their remedy.